name is Trey Reckling with the Academy of Cannabis Science, and we're so glad to have you here today. We have a group of students who are really excited to engage in a chat this morning with Aaron Pelley from Cultiva Law. Aaron, welcome. You and I have just gotten the opportunity to meet each other recently, but like I was sharing with you, we're very excited to have you on and talk about your specialty. So if you don't mind, talk to us a little bit about Cultiva and what you do with them.
Sure. So I started back in 2006 and just kind of freshly out of law school. And I ended up doing criminal defense, but the only kind of criminal defense that I could really see myself doing was representing criminals that I could imagine committing the same kind of crimes that I could imagine committing. So that ruled out a lot of more lucrative areas of law. But what I ended up doing was mostly representing cannabis patients and cannabis. And it was kind of like really at the renaissance of that time. There was a lot of people that were growing cannabis and using it medicinally. And in a lot of ways, it was advancing, it seemed like back then, in ways very quickly. And so, and plus it was just really fun to being a criminal defense lawyer. Doesn't necessarily evoke the image of somebody with a white hat, but when you're representing, patients, sick patients who are growing plants, it really was really fun, and we won a lot, and we got really good at it. And then over time, the laws changed, and all my outlaws wanted to become businessmen. And so they started coming to me with their lease agreements, and they started coming to me with their contracts and their partnerships. And even though there wasn't a ton of infrastructure that supported contracts between essentially criminals, well, I like to call them outlaws, but you can call them what you will. There was questions of whether it was even enforceable. But again, 502 happened, and interestingly enough, there was quite a fracture between the medical cannabis community and the recreational community when that law came to pass. But that law did pass. And actually, again, going back to the Cannabis Alliance, a lot of the people that I was working with back in the old days, back in the days of the medical days, are still there and part of the Cannabis Alliance today, which is pretty fantastic. There's not a ton of people left, but I feel like almost all of them are in the Cannabis Alliance. Anyways, going back, my firm had to change, like the laws. There were less and less criminals to be represented, more and more businessmen. And so I recognized that my strength was being in the courtroom and being a trial lawyer. So I continued to do that, mostly representing businesses against the Liquor and Cannabis Board. So when they're getting violations for whatever they're doing, a lot of my representation comes in that. And then I oversee actually offices here in Seattle and Portland, Los Angeles, and San Francisco, and we're opening an office in Las Vegas. And so my job is also to kind of steer a larger ship of a number of different attorneys, and they're different, and they all work under the Cultiva Law banner. So we've got a big team. We're growing fast.
That's great. Congratulations, and thanks for being on the good side of things. Or the cannabis fam side of things. We know, patients have increasingly gotten protections, but as you know, that wasn't always the way. And even now, people can find themselves, get into some trouble and be compromised by the law. Could you talk to us? You're talking about defending businesses against LCB charges. Could you talk to us about? I know you can't share details, but what are some of those things? We work with a number of students who work in retail. So what are some of those infractions or violations that LCB is actively enforcing?
So the big ones for a while were what they call true party of interest violations, which was they were vetting people's money forensically and making sure that it didn't come from certain places. At first it was kind of most of it revolves around wanting a real separation of church and state, I should say, between producer processors on this side and retailers on that side. And they don't want to know that either one has an undue influence over the other. They believe that this sort of vertical integration invites organized crime. It's actually a throwback, not only idea, but belief system from like literally the 30s. And they've been holding tightly onto it despite the fact that there's no evidence of that being true in multiple jurisdictions. But it doesn't matter. That's what we get. They call it tied houses. And so there's a lot of that financial work going on. And then they were really aggressive. they used to always show up with bulletproof vests, guns on their sides, and they roll in with like 7 SUVs at once and just raid a place. And they used to just act like cops. They've toned down quite a bit since about 2019, but from about 2015 to 19, in 4 years, they were very, very aggressive. And they enforced everything from, going into stores and doing stings for the under 21, which I don't think anybody has an objection to very obscure things like, financial violations, pesticide violations. I mean, it kind of runs the gamut. There's a whole, I guess you'd say, section, the Washington Administrative Code, of all the rules they have to follow. If your spouse moves out of state, for a while, that was a violation because you all have to be residents of Washington State if you want to be on a license. So it really ran the gamut. Oh, I think you're muted still, Trey.
I was, thanks.
There you go.
We even hear stories of the LCB coming after people who have parties in their homes, who are having consumptions, but the parties might be affiliated with the group, but they're in someone's home, or really coming down on consumption at events.
So they really don't like that. They don't necessarily have jurisdiction over it, but they just don't want it. So they don't want public consumption because they think that shouldn't be allowed. They don't want delivery because they think that shouldn't be allowed. Again, just kind of this, but they really, in some ways, their jurisdiction is very limited. They're only allowed to really go after, enter into the businesses. And as I tell a lot of my clients, when they come into a business, they have complete jurisdiction to ask for any document they want, to go wherever they want, and you really can't stop them. But a lot of times when I tell my clients, especially the owners, it's like they all have my card, and they basically just advise all of their employees, you're not allowed to answer questions, you're not allowed to talk to them. If they ask you, what the weather is, you're supposed to say, my attorney's Aaron Pelley, I'll answer questions when he's here. But other than that, we don't talk. But you're also cooperative, right? You're not a jerk. You still, if they ask to go somewhere, you open the doors and get them to it. If they want to see the camera footage, you show them where it is. You still have to give them access to things, but you don't really, we really advise them not to necessarily talk to them, because at the end of the day, it still really is, they're quasi police officers, and really they're a complaint-driven agency, which is probably the strangest thing about the Liquor and Cannabis Board. I have clients who still have not met their enforcement officers because they're very small people or small businesses. But the larger you get, the more likely you're going to get a complaint, and I put it in air quotes because it's really actually it's the competitors complaining against each other. So even though there are some legitimate complaints going on, the Liquor and Cannabis Board isn't just showing up at places and inspecting. They're literally a complaint-driven agency, so they don't do anything unless somebody complains about it.
So it's true that brands are snitching on brands about label infractions or having their stuff tested and saying, hey, it's going above, the 10 milligrams it can have in it for THC and stuff like that, huh?
Yeah, all day long, all day long.
That's
it's sad, but it would be disingenuous to say that I think that makes up at least half the complaints.
That's sad. Now, to be fair, there are, I'm sure, bad players in the space, people who are not keeping in the lines of the law. And I know we've had people lose their licenses for diversion and things like that. What advice would you have for an employee who has no ownership, has no control over the maybe larger operations, but realize, hey, there might be some shady stuff going on in my store? Have you been asked that question, or have you come up against that?
I haven't come up. I mean, I mostly represent owners. So a lot of times what I'm hearing is like a partner being concerned about another partner engaging in criminal or diversion activity. And in those cases, we move pretty quickly. It's a very strange and tense relationship that you have with the Liquor and Cannabis Board, right? Because at least because I've openly got them on panels and talked to them and been like, I can't call an airstrike in on my own client or myself, so to speak. I can't say, I think these things are happening at my location without you coming in and still saying, well, I'm going to revoke your license and here's your violation notice. So if I had that kind of liberty, then we would do it. But otherwise, we have to deal with it internally. If I was an employee, nobody's worth getting me involved in a felony. So, I don't think anybody else here wants to, get involved in that either. So that's just kind of unclean hands, right? So you just want to, if you think bad things are happening, work somewhere else. At the same time, you know, I have a lot of clients that are, how would you say, they haven't really ever learned to properly work within rules. So there are a bunch of outlaws that I'm reforming. Even to this day, they've been in the business for 6 years. And I'm still like, you can't do that. You have to do this.
Right.
And they'll fight me on it, but eventually, you know, like I beat them up until they'll do it. But it is the nature of this business draws a certain kind of person, and you have to be a little bit crazy, right, to do this. Like, it's federally illegal. It's, you know, it's not, there's no promise or guarantee of being rich. It's a lot more people fail than succeed in the cannabis industry. So it can be, you have to be just a little bit nuts to start with.
Yeah, and you can't write off regular tax stuff. You can't declare bankruptcy. It's you are operating a fine line. And that was going to be my next question about compliance. Yeah, there's some cowboys and there's some people who are like, hey, well, you have to just work the system in order to succeed, and that's the way it's always going to be. What kind of coaching do you do with licensees to say, hey, these are some of the high level things you just need to have in place so that you don't attract unwanted attention from the LCB? Is it SOPs? Is it training? Are there other kind of high level advice you try to guide them on?
I think it is just like any small business, and for entrepreneurs, this is going to be true, is that it's got to be scalable. And so if you're that employee that recognizes where you're at, or you're that owner that you know where you're at, even myself, you know, there was a point where I was like, I shouldn't be doing my own accounting. I really am not an accountant. I shouldn't really be handling my own IT work. And same thing with compliance work. There's, you know, if it's you and your wife and you're running a business, a small business, and you have one employee, I think you're going to be okay. But if you've scaled up to 20, 30 people, you need to start getting some systems in place to prevent, because that's the big takeaway about the Liquor and Cannabis Board is, if your employees commit violations, it's on you. And so if you don't have control of that situation and eyes on that situation, they don't really care. It's for them, that's not the question isn't whether your employee did it or not. The only question is whether it happened or not. So that can be a mitigating factor, but if they don't like you and your employee, you know, you might lose your license.
And that's a huge deal, and a lot of jobs lost and everything else. So thanks for pointing that out. I wanted to ask, you know, we work with a lot of authorized patients, and so they can own or they can possess more cannabis than the average person. What advice do you have for a patient like myself who can own several ounces but and can grow? Are there some best practices, or are there some things that we just need to keep in mind for personal protection?
Oh, that's a lot to unpack.
Yeah, I know.
I mean, if I were to parse it apart, I guess the first would be like, you know, I kind of always go back to my old mentor, who was a criminal defense lawyer, Jeffrey Steinborn, and he used to always say, just break one law at a time. You know, if you're going to break a law, just break one at a time. You know, if you're going to have a trunk full of meds and you know it's more than you should have, then maybe use your turn signals. I think the more nuanced parts of it end up being, especially for patients, is really remembering where you're at and how you're doing what you're doing. I get calls almost every summer. I'll get 5 or 6 phone calls throughout the summer of kids or adults, and everybody's a kid. I'm 50, so not everybody's a kid. Younger people get caught going to campgrounds on federal land, and they get tickets for marijuana violations. And you know, they're not going to go to prison over this. But they're going to end up with a federal conviction for marijuana possession, and you can never get that off your background check. There's no expungements. There's no way of getting that out. So you have that forever. So then every time you apply for a job, you've got this possession case, you know, so even though it's legal, it doesn't, you know, so is DUIs or drinking in public. There's lots of things that aren't that big of a deal. But if they see a criminal conviction on your application and one without it, and otherwise the two of you are the same, they might pick the other person every time. So those kind of things they're not a death sentence or an economic, you know, impairment, but they can be. And so you really want to know that, like, you know, you know, it's still federally illegal in those parks and those national parks. I mean, there's places in Washington State where you can be driving and you are on a state highway, and then all of a sudden you're on a federal highway. And there's no knowing that. And so you get pulled over by these really, hyper aggressive camp rangers, and they'll give you tickets, and they'll do it all day long. And they seem to take a particular pleasure in doing it. So I think that's one of the ones. The other one is that really just being aware of your plant count if you're growing, just being sensible about it. Everyone, when they get in trouble, always has a reason for why they have more plants than they should have, an explanation for me. But a plant, it becomes a plant at a certain growth stage, and it's very clear on the RCW 69.51A on what you can and can't have for the number of plants and when a plant becomes a plant. And I want to say it's like when the leaves become like a certain millimeters, and there's identifiable roots. So it's not that long. We're talking 2 or 3 weeks in the growth stages, and it's from a clone. And so at that point, you've got a plant. So even though it takes you a certain amount of time, and yes, some of them are going to die and all these other things, at the end of the day, your plant count limit is on your authorization. And those folks just need to be, you just have to be, you either do that or you accept the consequences for having too many. And they're still kicking people's doors in. Actually, down in Olympia, I just got a phone call for somebody got their door kicked in, and we're getting prosecuted for 50 plants. So.
Wow. Yeah, good to know. And 50 plants, like you said, can be a tray of seeds you've popped.
Yeah, I mean, over half of them were. And he had the same explanation. Well, half of them are going to die. And I got to get these ones to grow before those ones will grow. And it's like, I understand all the reasons why you did it, but it doesn't mean that they're not going to prosecute you for having 50 plants when you're only supposed to have 15.
Yeah, and people growing from seeds are going to lose 50% on those males that they're going to call. So I totally get it. And so talk to us about sticking with patients for a minute. Patient database. It's maintained by the state. Some people are really concerned about it. I want no part of it. Other people are like, well, it affords arrest protection. That's another level of protection. I'm assume that I'll be able to benefit from. What's your advice to a client, or is it a case by case?
I mean, for me, so arrest protection, we fought so hard for to finally get that. And you have to understand that it's literally bulletproof. That like, if you have less than 6 plants and you are in the database and you have less than the weight amounts that I want to say it's 3 ounces still. It shouldn't be that low, but I think that's the number. But, I didn't do my disclaimer for everybody. Trey and I were talking about beforehand, but I do want to say, like, as I'm telling you guys all of this, it is for educational purposes. I'm not trying to give you legal advice necessarily. I can. So if you guys want to tie me down on any of the things we've talked about and say, Aaron, I appreciate what we did educationally. Now I need to hit you up for legal advice. I'll leave my contact information with Trey at the end so that you guys can talk to me about that. But sorry, going back to arrest protection, I just want to say, like, what everybody has that's a medical marijuana patient without being in that database is the same thing that you would have for self-defense. And so it's an affirmative defense. And so, if somebody breaks into your house and they have a knife in their hand and they say that they're going to kill you, and then you shoot that person, that's self-defense, right? Everyone knows that's self-defense. But the truth is that you murdered somebody. You have a defense for murdering somebody, but that is still the crime that was committed is murder. And the prosecutor legally can still prosecute you for murder. There's the prosecutor has no duty to bring up your self-defense claim. So the self-defense claim is something that you have to bring up and that you have to prove to the jury at trial. And so there's no point where you can bring it to the judge or anyone else. Your affirmative defense is something that you get to bring to a jury. And the prosecutors can prosecute you all day long for murder. And the same thing is true if you're not in the database and you're not under 6 plants. The only thing you have is an affirmative defense, which means that you can defend yourself, but there's nothing that prevents a prosecutor from prosecuting you, and there's nothing that prevents a police officer from arresting you, and you having to go through that process. And so I guess that's so that isn't to tell you whether you should or shouldn't use that database. I will tell you they've locked it down. Not anybody can get access to it. Literally nobody can, except for a very select group of people under very select circumstances. I understand people's historical distrust with databases and their ability to keep them private. So for that reason, I don't take a position on whether you should or shouldn't do it. I just like people to know what you're getting versus what you're not getting. So the police don't have a right to arrest you. The prosecutors don't have a right to prosecute you, and you have complete arrest protection which means I can go back and sue them for arresting you if you're in that database and you're under the plant count, which is kind of a big deal for me. It was something we fought really hard for. Did that answer your question?
It did. And so how actively, so if a policeman comes in my home and finds that I'm in violation of my possession limits, are they then on the phone to check that database to see if I can be I'm sorry.
If you're within your numbers,
within my limits,
you pop up with your authorization card and you say,
right.
Here's my authorization card, here's my database reference number. And they type that number in. The only thing they get back is says, yeah, they're in the database. It's like the cops are like hands off.
Okay. So carry that card with you like you would carry your driver's license, even if you're not going to a cannabis store. It
has value. I mean, if you're going to be in the database, you might as well take advantage of the value of having it.
Excellent. No, that's very helpful. And some people, yeah, and like we know, those of you in the class, those of you who are already consultants, and those of you especially who are working in stores, that we're never trying to urge a customer this way or that way. We want to remain objective, try to give them a good understanding of their choice to participate in the database, just like Aaron has said. So, but we're not personally taking a side. So talk to me about traffic stops a little bit, if you don't mind. Could you give us some best advice? I know sometimes people want to be helpful and they get pulled over and, I don't know, they might have smoked a joint in the car or they might have some in the trunk, but people, I think, generally want to be helpful. And I know a lot of cops are trained to encourage you to be helpful, but at your own expense, possibly. What's the best advice on it? And I know this is a very generic question, but what's your best advice to people if you're just educating when it comes to being stopped by the police?
This is one of the biggest, we're talking earlier about the 502 community and the fracture between the community and this recreational law being passed and the medical cannabis community. And the real breaking point for that actually was the DUI laws and the 5 nanogram limit on DUI. And for those of you that don't know, the way that your body works, and at the risk of you already learning this, I'm just going to say, the way your body works is when you take a hit off of a joint, you pop up somewhere between 200 and 230 nanograms on a scale, and it just shoots up on a curve like this. And then over a 2-hour period, it goes down like this until you get to about 5 nanograms. And so you've got this pretty steep curve going up and down, which is what's common for most people. But what they've learned in literature, and maybe what you've already learned in the literature as well, is that it's not uncommon for people who use cannabis. The word they use is chronic, which is kind of funny considering the term, but they use cannabis chronically or regularly, would be more to the point. They can show up at 5 nanograms when they wake up in the morning. Some of them were testing in isolation at 7 nanograms 2 days after they had last used. And so what does that tell us? That tells us that you could literally be sober, not be using cannabis, and actually be under the law per se, under the influence, which you don't even have a defense. It's like being over 0.08 with the alcohol breath test. In other words, the prosecutor doesn't have to do any work. They just hold up your blood test and they say, you're over 5 nanograms. He's guilty. You don't have to do any work, Jerry. Just read this piece of paper. I guess what I was saying with that fracture with the community, I think had to do a lot with, and this has to do also with kind of what you guys are dealing with as dealing with people that are using cannabis medicinally. When you are using a drug recreationally, you're functional and you're trying to get impaired. But when you're using a drug medicinally, you're impaired and you're trying to become functional. And that distinction is worth going into because of the way that it the way it impacts your use. And so that's to say that if I take my father-in-law's heart medicine, it's going to make me feel weird for about two or 3 days. It would just mess me up. And the same thing is true actually for people that use opiates. If you use opiates regularly, your body gets used to what we call like the roller coaster experience. And so all of this is actually true for cannabis. You know that you're using a drug very regularly, all the time. Your body's going to build up a certain amount of, not necessarily immunity, but you get used to the effects in a way where you're going to need more and more to get the medicinal benefits from it. And again, there's no harm in this. And in fact, out of all the drugs you could use, cannabis would be the best. But going back to that traffic stop, or where we started, you know, there are real concerns for especially medicinal patients that use this very regularly. You know, I don't want the guy, I represented a guy who had epileptic fits, and cannabis controlled that. And he had been using cannabis, and he was at like 5.5 nanograms. And it was luckily at the time when 5 nanograms wasn't the limit. But had I defended, and he won, we got a not guilty verdict from the jury. But had we, that same case come out a year later, I would not have had a defense for that guy. I just would have had to plead it down. So I guess, sorry, going back to the traffic stop. So obviously, for medical users, you really want to be hyper conscious of smell. You want to be hyper conscious of, you know, what you're bringing with you. We all have smell blindness. We don't necessarily know how we smell when we leave the house, but you should be aware, if you're a medicinal user, you know, that when you're getting in the car and you are truly 5 nanograms all the time because of how much you're using, that you're really just, again, going back to Jeffrey Steinborn's saying, you really just want to only break one law at a time. And you know you're breaking the law right when you get in the car as a medicinal patient. So after that, I tell clients that, you know, everything that the officers say is to make it sound and seem like it's optional. They have ways of phrasing this. So when they ask you to step out of the car to do some voluntary tests, your answer is that I will step out of the car, but I'm not agreeing to any voluntary tests. You shouldn't supply them with evidence for a case that you know they're already making against you. Again, I also encourage my clients not to agree to a blood test. Ask them to get a warrant. Again, that just runs the clock longer for me. It takes them about a half hour to 45 minutes to get a blood test. Again, for chronic users, I doubt it's going to make a difference. But for the person that smoked a joint 2 hours ago, hopped in the car and is not sure if he's 5 nanograms or 6 nanograms, might as well let the clock run and get under 5 nanograms as soon as possible. I know a lot of this also sounds like I'm gaming the system against the police, but at the end of the day, I'm not here to help them. I'm here to defend my clients. And so I just want them not to give them any extra or additional evidence. And again, I just to say, kind of playing off of what I was talking about earlier with when the LCB shows up, that doesn't mean you have to be a jerk. You know, like there's no benefit in doing that. You can be polite and exercise your rights. You don't have to completely, you know, scream, "Am I free to go?" and everything else that the kids on TikTok are telling you to do. You can just politely exercise your rights, which is, I'm not going to take any field sobriety tests. I'm not going to agree to any blood tests. You know, I'm exercising my right to remain silent. And that's very easy for me to tell you to do. It's a lot harder to do when you're sitting on the side of the road and, you know, you had a joint 2 hours ago and there's a guy with a bunch of blue and silver, you know, staring you in the eye. So, but that's my advice.
And it feels like you're being non-compliant on top of that by saying no. And it's hard for some people just to say no, but when I think they realize how much is at stake. Could you just give us a thumbnail of, in Washington State, if you're convicted of DUI, how does that impact you? How expensive is that? Because I'm sure you see this frequently. What kind of impact does that have on people's life? Just a first offense.
So there's a mandatory minimum jail time of 1 day. There's like there's license revocations for windows of time. I should point out, because it is worth pointing out, and this is the weird and interesting balancing act, because a lot of clients have told me, I can't afford to lose my license for a year. I can't afford to pay all those fines, pay a lawyer, and I can afford to you know, deal with the criminal conviction of maybe a reckless driving or negligent driving, but I can't afford to lose my license for a window of time. And I can't remember what it is, but by failing to refuse to engage in a blood test, you can refuse the field sobriety test. But if they ask for a breath or blood test and you refuse, legally, there is a consequence for that, which is you do lose your license for a window of time. I can't say the exact time because it's been a while since I practiced this area of law, but it is a consequence. So it's something you have to consider. But if the exchange rate is, I might be more likely to pass that blood or breath test if I wait and refuse while they get a warrant, then I would encourage you to do that. But if the exchange rate is, I can't show up to my job in Everett and I work in Seattle, and without my job, there's really no point in any of this, then maybe you have to make that hard decision right there on the spot. So it's just something you kind of have to, there's no real easy one answer for all of this.
No, but it's heavy duty. And I think, thanks for reminding people that, some of us are never below 5 nanograms as patients. It's just not a reality. So I don't think the smell of cannabis is rights to search a vehicle, but it certainly can prejudice an officer if you smell like weed, and it certainly leads to further questions. You're smiling.
They use this holistic, they're called the DREs. They use this holistic way of getting probable cause to do the arrest, and they have all of these goofy things that they've collected over time. One of them is that you have a green tongue, which is hilarious whenever I see a police report and an officer says he had a green tongue. I mean, I've been hanging out with cannabis users for almost my entire adult life, and some of even my younger life, and I've never seen a green tongue. That doesn't exist. It's not a real thing. And whenever you corner them, and when you look up where they came up with this, it was just some random guy that added it as part of his research evidence for how people are so. The other one was trembling hands. So you have a green tongue and trembling hands. And by the way, anybody that doesn't have trembling hands after smoking a joint a few hours ago and getting pulled over by a cop probably isn't normal to start with. But they have all these different things that they'll take collectively along with the smell of cannabis, and they'll be like, at this point, I think that there's enough here to get this, to ask you to step out of the car for a field sobriety test.
Yeah, and all that's really scary. So we just want to talk about it in advance. Once again, we're going to put Aaron's contact information here in the chat so that you can reach out. It's don't pretend to be a lawyer if you're not one. Don't, like Aaron said earlier, don't do your own taxes if you're not a tax person. Those things can be expensive. And so I want to give other people a chance to speak. Before, we do have a question from TJ's about the way that they're testing people's concentration of THC is what they're testing for in their bloodstream. They had talked about a breath strip at one point, and I know they have these kind of fake breathalyzer things they're trying to use in some jurisdictions that are supposed to measure THC, but I think scientifically they're far from even good right now.
Yeah, they haven't got there with the strips yet. They're trying it in different. They haven't tried it in Washington yet. They're still doing blood tests. They've got them down to a hard science to get them done faster and faster because lawyers like me are advising against them. So I think they've got it down to like 30 or 40 minutes in some jurisdictions where they can get a warrant. And once they got the warrant, by the way, there's no point in fighting them at that point. They're allowed to kind of do whatever they have to do to get you to comply.
Okay. So you all get the message. It's very expensive. It's life-changing event. So as much fun as anyway, you get the point. Chuck makes the posts about DOJ recently published a report saying roadside tests don't show THC impairment. Are you aware of that, or has?
Yeah. I mean, we use those. I mean, it does. Prosecutors still prosecuting, despite the fact. Yeah, not only does it not show roadside impairment, but they've said that that's not what it was created for. Like, it's the wrong test to be doing. There's another test that they do. They call it the DRE test. That's supposed to be really highly accurate, but even the pseudoscience in that is a lot of nonsense. And if you talk to and I don't consider myself a high level DUI cannabis lawyer, but I've done enough cases to know that their science is garbage for the DREs. We have our own DRE expert that kind of tears them apart every time. And you're absolutely right. There's only 3 of the tests that are supposed to be that may be helpful in determining whether somebody is using THC or THC impairment. But we're pretty good at pointing that out when we get to jury trials and things like that, but they still use them, and they still try and use them to prove their case.
Thank you. And nobody wants to be in the position also of being on the side of the road, following the flashlight, not worrying about the car zipping by at 70 miles an hour, with a policeman staring at you, standing in front of a body cam and a car cam and all that stuff. We just don't want you to be there. What questions do you all have? I've taken a lot of Aaron's time, but we want to make sure you all have an opportunity. Mary, did you raise your hand?
Yeah, she's on mute still though.
Yeah, you're muted, but you're welcome to ask a question.
Unmute myself.
There
Okay.
we go.
Okay, so what do any of these laws pertain to edibles or anything like that?
For sure. So I guess you mean like, so there's definitely laws on the medical side for edibles, what you can and can't do. And then there's laws on the recreational side for when you're a licensed user. They've really, on medical, they've taken a really hard stand in terms of edibles and using concentrates. That has to do with, people blowing up houses and things like that. So there's some pretty very sharp delineations on what you can use to do edibles. And I mean, it really comes down to like, you can use butter and some of the natural drawn, but you can't use any of the concentrates that are butane driven or boy, I'd have to go back and pull the law, but they really tightened up things in terms of edibles and what you can and can't do with combining. And then of course, as if you're talking from again, a medical cannabis patient, you have to be kind of thoughtful of who you're providing that to and how you're providing it so that you're being safe. There's the health and safety. Just common sense, I guess.
And with regard to blood test, Mary, anyway, it doesn't matter how it's entering your bloodstream. They won't worry whether you had a joint or had an edible or hit a vape. It's all about that measurement of THC in your bloodstream. So it's a very narrow way to look at things. Even the National Highway Traffic Safety Board has said, they can't find a true link between cannabis intoxication and poor driving. But that's not what they're worried about with the law. So absolutely, edibles can also, they can impair you more than you think, especially if you're not.
Oh, I'm sure they can.
Yeah, right. So
I totally misunderstood your question.
Yeah, sorry, man. Brownies in my time.
So for sure, yeah, we really got to watch the edibles because they can sneak up on you and affect you more than you know.
Yeah, I imagine they can. I've had some brownies. I mean, imagine.
What other questions we have? Because I got more always.
Oh, how cute.
Aaron, could you talk to me a little bit about when it comes to, we have all this technology and it's convenient, but, some people don't keep their Alexa plugged in because they're worried it's always listening to them at home or that their phone might be doing the same. Some people have fancy anonymizer private message apps, WhatsApp, Signal, and things like that, and use them with not abandon, but a feeling of impunity. Say, well, if we use that app, I know especially a lot of people in cannabis industry, they're like, well, talk about it on Signal and we're safe there. But is that discoverable? Can a police person look at my phone? How does that work? If a policeman asks to look at your phone, I don't have to give them my phone or open that phone for them, do I?
No, you shouldn't be opening your phone or your door for police if you can avoid it. Actually, believe it or not, like everything I've heard on Signal is pretty good in terms of its ability to prevent being found. But I'm always suspect of anything that promises that they're doing something that I can't see is being done. Everyone was convinced that that was true for Snapchat, but it ended up being that Snapchat had kept like a huge database of all the information that had been going there. I don't know if they've since cleared or fixed that, but it just kind of speaks to the fact that we don't know what's happening beyond our view. And there is nothing that prevents DEA or police officers from getting warrants and kind of getting in front of or between you and a provider. So those are some of the concerns that people express kind of in the criminal defense community. I mean, it's kind of crazy, the technology, and this was even back this is in the late 90s, early 2000s. Police were able to get reverse search warrants, or they call them reverse wires on telephones, where they could literally turn the microphone on the cell phone of somebody and start recording where they were at. So they weren't listening to their phone calls; they were listening to their everything. But I would also say that I tell all of my clients that more likely than not, you're not that interesting. You know, when it really comes to phone communications and what we're doing in our communications in our day-to-day operations, the people that are really getting search warrants for phones and listening in on phones are DEA agents and folks at kind of a higher level, and they're looking for people that are engaged at a higher level. You know, folks that are growing weed in their mom's basement and or engaging in kind of the normal cannabis community. The feds aren't that interested in us anymore. They haven't been for, well, really since about 2013. It's not to say that they can't or they don't have the ability to do it. It's just more of a you know, a likelihood. It's you're going 57 miles an hour if you're in the cannabis industry. The speed limit's 55. So it's not a speed option, it's speed limit. You're breaking the law as soon as you do anything with cannabis. We're all federal criminals, but you're going 57 miles an hour. The likelihood that you're going to get pulled over doing that is really low. It's just doesn't mean it's not illegal.
Gotcha.
If nobody else answered the question, can I ask one more question?
Sure.
If you work for the state of Washington, is it illegal for you to have a license?
Oh no,
Just curious.
no, working for the state of Washington, not at all.
Really? And
no,
all license of state of Washington?
Yeah, the only time I ever see anybody having issues with having a cannabis license and being engaged in another activity has been doctors, which is and because even and it has to do with their DEA license, where I've ran into that. I haven't seen anything. And then a few people that have federal contracts with the Department of Justice at kind of a really high level. And I think they're just more, but as far as just being a Washington, I mean, Washington collects more money than anybody from this. I mean, they're at 37% tax. I think that Washington very much embraces the cannabis industry and what we do. So I think that the Attorney General's office is very happy that we're here.
Okay. So you can work for the state of Washington, no problem.
Yes, absolutely.
Okay.
And actually, if it's worth pointing out or not, like you can also have a criminal history.
Wow.
You know, you can your felonies have to be over 10 years old, and your gross misdemeanors have to be over 3 years old. But other than that, criminal history does not necessarily preclude you from being a licensee. The problem with licenses, is that there's only a finite number of them. So they're like taxi medallions. You either got them or you didn't back in the day. And now they sell in the open market for hundreds of thousands of dollars.
For sure. Yeah, very difficult to get. What, Aaron, and this kind of branches out a little bit from what we're talking about in cannabis, but Washington recently made the determination that personal amounts of any drug are not necessarily illegal or can't be enforced. I know there's this whole gray thing about that's come out recently. Yeah, so how would you describe that to somebody? I know it's very complex, but elevator talk.
No, the Blake case, I mean, it's kind of complex, but not really. I mean, almost every state except Washington already had what we call intent attached with possession. And so that if you possessed some amount of drugs, there was intent. So earlier when we were talking about 5 nanograms, we said the per se rule. We had a per se rule also for possession, which per se means there's no argument about whether you knowingly were over 5 nanograms, or you were willingly, or you were recklessly, or you were negligently over 5 nanograms. You either were or you weren't. And the same thing was true for possession. There wasn't ever a protection against, and that was what Blake was doing, is she had like a little bindle of methamphetamines in her jeans. And she said, hey, I bought these jeans from a secondhand store like 2 days before, threw them on. I didn't know where this came from or whose methamphetamines they were, but it wasn't mine. And so she wanted to do this affirmative defense, basically said, I didn't know. And she got shut down until she got all the way to the Supreme Court of Washington. And the Supreme Court of Washington was like, look, every other state has included intent into their possession laws. And Washington's been well aware that they should have fixed this, and they didn't. And so we're going to punish you, Washington State, now for not fixing your laws and adding an intent to your possession laws. And so they basically said all possession cases are thrown out, and actually it's kind of for what it's worth, I don't believe it'll remain this way. I do believe that the legislature will fix it, but for every day that they haven't and don't, it's another day where we can say the sky didn't fall. You know, people always ask me if I believe that all drugs should be legal, and kind of, and I always say, yeah, I do. I actually do. I don't think that there's any benefit to this drug war at any level. I just think that the worst of it happened in medical cannabis and cannabis. But that isn't that we shouldn't get all of this out of the hands of cartels and drug cartels and put it in a position and treat it like a public health issue. So, so I think that it's awesome that that is happening and that it continues to be the case, because we've proven that the world didn't end just because we made it legal to possess drugs.
For sure, and anytime we can reduce connection or any kind of contact with law enforcement, we know that cannabis is dangerous because it's illegal, not illegal because it's dangerous, right? The most dangerous part of cannabis is your interaction with law enforcement. That's not to say that all cops are bad, but we know a bad cop is a deadly cop, right? And we continue to be reminded. So not to damn the whole institution, but just like the Catholic Church learned, if you don't get rid of your bad players, we will always be painted by the same brush. So hopefully
That's right.
they're starting to understand that, and they got to help us fix the problem in their ranks.
Charles asked a question over in the corner.
Yeah, I was going to point that out. Charles asked, did you already get a chance to read that?
Yeah, about, well, I'm reading the bottom one first, but it was just about edibles.
Yeah, sharing edibles, and what kind of jeopardy does that place? We know we can share cannabis in the state within a possession limit. You know, I can share up to an ounce with you. I think it's supposed to be store-bought cannabis. I can't share what I've personally grown as a patient with you. But if I can, you know, instead of bringing a bottle of wine to your house, I can go buy you a quarter ounce if I'm coming over to visit, right?
That's correct. Yeah, that's absolutely correct. And then I guess yeah, so again, for a long time there, and for the law was that, you know, if I was smoking a legal joint that I bought it from a 502 store and I passed it to you to smoke off of, I know that sounds horrible in the age of coronavirus, but we used to do that, that was a felony distribution. They changed that law and fixed it. So you can share your drugs that have been bought in a 502 store with other people within the limits of those drugs without committing a crime of what distribution, I guess you'd say. So now, was that both questions?
Where that changes, Chels, I believe if you're charging, if somebody were to be charging for that and doing so without a license, then you would be breaking the law. I don't know how well that's enforced, or if, you know, how that would become enforced unless, I don't know, your greatest risk, we'll ask Aaron, your greatest risk might just be by somebody narking you out for it, right?
Well, I have to go back and read the laws, because I think, again, the law allows you to take your cannabis and you can do stuff with it, but you just can't, in other words, you could turn it into, I could buy like an ounce of a weed and turn it into a butter and do something with it. And again, share it with other people without quote unquote processing it, but I can't process it at the level that the processors do in the 502 industry, where they're doing butane extraction or isolate or things like that.
And that's what I understood too. So that helps. What would it be? Victor asked about donations. You know, back in the day, in medical days, everything was not a sale, but it was a donation. And that was the gray area I think people felt safe and protected in. Does that hold up in court at all? If you're saying, oh, it was free, they just gave me a donation for that that medical product that I shared with them, or that other product that I shared with them. Does that hold any water?
Yeah, it's kind of a throwback to the old days, Trey, when you and I, when we had 69.51 and we donate, and yeah, it's not necessary, I guess, anymore. Again, you can give somebody, you can possess and pass things back and forth that come from the 502 ecosphere. When it comes to medical, you can also create under the LCB, not collectives, but cooperatives, where you can as a cooperative, you can transfer cannabis as between 10 folks, and it's a very complex, not very complex, but there's a bunch of rules around it. I wouldn't be able to summarize in the window of time we have, but just to say that if you give them a reasonable amount of stuff that you get in 502, you can. Your medical cannabis is kind of stuck with you. We still do have designated providers, but you can't be a designated provider for more than one person. So if you decide you're going to grow for your sick mother, you absolutely can do that. You can grow for her and she can be your designated provider, but that weed is for her. It's not for you even. It's just legally for her. And that's the limits of the law.
Yeah,
you can, I guess you could be a patient and be a designated provider. So that's quick and fast. And
it's tough. I can't even technically share with my husband anything that I grow as a patient, right? He can look at it and enjoy it and everything else. Enjoy looking at it, that is. Y'all, thank you for the questions. We're right at time. We wanted to make sure that you saw Aaron's contact information. That's Aaron with 2 A's at cultivalaw.com. And so we encourage you to put that number in your phone or put that contact information in your phone. It's one of those things. We hope you'll never have to use it, but it's also, I think it's fair. I don't understand the law like you do, Aaron, but I think it's fair to say it's always cheaper to pay for advice and guidance on the front side than guidance when you're kind of under the gun, when you've been arrested and are already compromised. If you have any questions about what you're doing, get professional advice. Don't do it because 2 or 3 of your friends who you trust said that's okay. We're learning from the Matt Gaetz case that payments on Venmo and PayPal are very discoverable. Some people are like,
I always knew it.
Right? So we want to, we just want to be smart about what we do, and so that we're not. And there's Aaron's number, 206-480-1600. We encourage you to put that in your phone for a rainy day.
And honestly, if you guys have like a question, it's 5 minutes long, whether you're kind of in the retail or producer processor, or if I can answer it in 5 minutes, I'll do it over the phone with you. I was one of the few people that got through law school without learning how to type. Well, I can type, but like with 4 fingers. So
I did that in grad school.
It's really hard to watch me type, and all my employees are just like, they just cringe when they come in my office. Oh, yeah. So if you call me and you're like, I got a 5-minute questionnaire and I promise, I'll more likely than not answer it for you.
Great, thank you. And we're so glad to see some of you people who are leading retail stores on the call today. Hopefully that means you got your shit together and that you've got your SOPs and that you're training to those standards of practice. And you've got a plan for the day that somebody might break in to steal your stuff or confiscate your stuff with a badge or, try to give you a hard time. We hope you have a plan for all of that. But when you go to make your plan, spend some time investing with somebody like Aaron to really get your plan together to make sure it's watertight, that you're following good practices, because that always pays off. So Aaron, we appreciate your expertise today. Thank you for volunteering to spend some time with us this morning. And we want you all to remember Cultiva Law is not just in Washington, but where else now?
Oh, and we're in Oregon, California, and at the end of the year, we'll be in Nevada.
All right. And we got students in Nevada also. So thank you so much. And
all right. Thanks, you guys. Have a great day.